You know right, assassinate. Airport and Timaya. Moja nananu shegu edigu on my yeah.
Mimobi bi akwaba eba Melodies TV so dear enkrofo enim ene se ende 11th November the first public sitting on the LGBT, the anti-LGBT bill as Sam George any other parliamentarians they wamonsa ashase no na sa public sitting yi unsa enkrofo bebre edi memo saba na kire se enkrofo bebre na aba bonten aba betro se womo support bill no ebi mu nso ka se womo support na nipa ba kwa wono wo se won support lawyer Akoto Ampaw na ende na kire se wo bia wode ne memo ba bia no ye ma ne kwan se won betre die nti a wode na asem ba nti lawyer Akoto Ampaw ase wono on the side of the LGBT for no nti wo bekasa ye etre die nti a bill no mayem pene na LGBT for no yenja omo na womo ye de omo pese womo ye bia wo Ghana no wo tretre nsem ni so ebrobro nsem so na ensem ni bia wo kan no for me na metie na me say this particular reasons there ebe na den but eyo no na what the reasons no aba committee na wo mo atena se no e wo se wo mutie wo bia de na wo mo recommend a true report the common speaker of parliament obia be kasa Sam George be kwa kasa nsofo a wo mo nso atro in favor of the Sam George the ba no wo mo nso be kwa kasa nti no today is the first meeting I'm saying there enkrofo be 4 or 5 and e ba be kasa nti we are expecting more people without wasting much of your time no yenko tie nsem a lawyer Akoto Ampaw wode etudwa in support of the LGBT community.
Constitutional issues implicated by the bill and its provisions. 2. The unfounded premises of and justification for the bill. 3. The absurdity of provisions of the bill and a lack of understanding of the issues that the bill purports to speak to. And finally, my conclusion. Mr. Chair, it is our view that the bill violates Article 1, Clause 1 and 2 of the Constitution, the very first article of the Constitution, now, which upholds the sovereignty of the people of Ghana, in whose name, quote, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in the Constitution. So the powers of government, including legislative powers, are to be exercised only in the manner laid down in the Constitution and within the limits laid down in the Constitution, irrespective of the number of people that may support the piece of legislation. The legislation must meet that first provision, fundamental provision of the Constitution. If it doesn't, by Clause 2 of Article 1, that bill or that legislation is void. It's void. It means it doesn't even exist in law. Now, the combined effect of these two clauses is that the select committee and parliament as a whole has a duty it cannot shirk to ensure that any bill that comes before it, the first thing that it must determine is whether it has been introduced in Parliament in the manner laid down by the Constitution. And if it crosses that hurdle, Parliament and the Select Committee must interrogate and determine whether the bill and its provisions are within the limits, again, laid down in the Constitution. So if the bill is introduced in a manner that is not laid down in the Constitution, that should be the end of the bill. It should be rejected. This is the force of the Constitution. Again, even if it is introduced in a manner laid down in the Constitution, but it is not, the provisions are not within the limits laid down in the Constitution, it is to that extent void. Our respectful submission here is that the bill has been introduced in Parliament not in the manner laid down in the Constitution. This is because this is a private member's bill. And under Article 108 of the Constitution, 2 and 3, it is the President or his agent who can introduce bills generally in Parliament. And where a bill, however, does not impose a charge on the consolidated funds or any public funds, then it may be introduced by a private member's bill. Now, it is clear from the reading of the provisions of the bill that the bill will impose extensive policing duties on the Ghana Police Service if the bill is to be effectively enforced. Secondly, the bill with its provisions for so-called therapy, a medical treatment, will require in situations where the person responsible for the assault has no money, will require that the state steps in to provide medical services. These clearly impose costs, charges on the consolidated fund, and therefore ought not to have been introduced by a private member's bill. Yes, it is the case, and we admit that Article 108 states that if in the opinion of the person presiding, the bill does not impose a charge on the consolidated funds or other public funds. That is the text of the bill, of the law, of the Constitution. However, as we all know, and any discretionary power that is granted any person exercising a public function, like a Speaker of the Parliament, under Article 296 of the Constitution, must be exercised in a reasonable and not non-arbitrary manner and without prejudice. And where it is clear that the Speaker of the Commission of Parliament, as in this case, has exercised his discretion unreasonably by concluding that the bill does not impose a charge on the public funds, when it is obvious and palpable that the bill imposes a charge on the public fund, that decision of the Speaker is by Article 296 of the Constitution unconstitutional. And let us make the point clear that we live in a country under a democratic republic where we are not ruled by men but by law. So the Speaker is not above the Constitution. He is subject to the mandatory provisions of the Constitution. And it is our view that the Speaker violated Article 108 of the Constitution when it allowed such a bill that clearly imposes a charge on public consolidated funds and public funds to be laid before Parliament by. So, that's the first point. Now, Mr. Chair, our position on the bill is that it violates the fundamental human rights provisions of the Constitution. It is, in our view, a measure of the ultra extremism and totalitarianism of the bill that it somehow succeeds in violating virtually all the fundamental human rights provisions of the bill. Just one bill, one law, somehow has managed to violate every fundamental human rights provision in the bill. What do we mean by that? Now, by stigmatizing in the memoranda the LGBT community as inhuman or a taboo or alien to Ghanaian society, the bill grossly violates Article 12, guaranteeing the fundamental human rights of every person, subject only to respect for the rights and freedoms of others and the public interest. It equally violates Article 17, Clause 1 and 2, on equality of all persons before the law, because it separates LGBT persons as if they were not human beings and seeks to apply an equal law to them. Now, further, the bill seeks to promote customary values and practices which Article 26(2) of the Constitution prohibits as dehumanizing and injurious to the physical and mental well-being of the person. This bill, Mr. Chair, actually attacks the very personality of LGBTQ persons and dehumanizes them and seeks to cause injury to their person and well-being by the provision that makes them liable to imprisonment upon conviction for their identity or LGBT activities. Again, Mr. Chair, Clause 212 of the bill contravenes the fundamental right to freedom of expression and speech, including media freedom, guaranteed under Article 21(1)(a) of the Constitution. It goes to the absurd extent of criminalizing sympathy for a prohibited act and promotion of support for change of public opinion. The bill criminalizes the promotion of support for change in public opinion with respect to LGBTQ matters and sanctions that by a term of imprisonment of not less than 5 years and more than 10 years. So where a person exercises his freedom of conscience, freedom of expression, to sympathize with LGBTQ people, the sponsors of this bill want this democratic republic to make that a criminal offense, liable on conviction for a term of imprisonment of 5 years or not more than 10 years. Mr. Chair, this is not the republic that Ghanaians fought for. Now, Clause 15 seeks to disband any association or organization in existence before the bill. And Clause 16 seeks to prohibit the promotion, formation, registration of any organization or association with the purpose of promoting or supporting an act prohibited under the Act. Both clauses are in direct contravention of Article 21(1)(d), which guarantees the right to freedom of assembly, including freedom to take part in processions and demonstrations. So let's take a typical example. Supposing that, as is going on in the country right now, LGBT people are being attacked and beaten up, thrown out of their homes. If this bill became law, they don't have the right to go out and assemble and demonstrate to bring the state's attention to the fact that they are being assaulted. If they did so, there's double jeopardy. Because in addition to the fact that they are being beaten and attacked, they would have committed an offense under this act and will be liable on conviction to terms of imprisonment. A lady we are aware that the argument has been made that nowhere in the bill, in the Constitution, is there a reference to sexual orientation, sex identity, and so on. Our question is, the Constitution does not anywhere guarantee the right to sex. But any attempt to deny Ghanaians of their right to sex would be a violation of their human rights. Again, the Constitution does not directly make provision for the right to food, but it is well established within the human right domain that every person has a right to food. And again, the view that there's nowhere in the Constitution where there is a reference, a right to sexual orientation or identity and so on, can only be made in ignorance of Article 33, Clause 5 of our Constitution, which provides as follows, quote, the rights, duties, declarations, and guarantees relating to the fundamental human rights and freedoms specifically mentioned in this chapter shall not be regarded as excluding others not specifically mentioned, and which are considered to be inherent in a democracy and intended to secure the freedom and dignity of man. So our view, our contention is that this article, this very important article, provides a broad space for recognition of other fundamental human rights that are not specifically mentioned in the Constitution. And therefore, the argument that the right to sexual orientation or identity or expression of LGBTQ people are not guaranteed under the Constitution falls in the face of Article 33, Clause 4, or this Clause 5 of the Constitution. Mr. Chair, I'll proceed to Part 2 of our submission, that the memorandum to the bill premises the bill on a number of unfounded justifications. First is the purported protection of Ghanaian family values. That the argument is that the bill is necessary to ensure that the family as a unit and protection of human species are sustained. This premise is, however, not supported by any data, absolutely any data, showing that the family as a unit is threatened by LGBT activities. On the contrary, or that procreation is threatened, the human species is threatened by LGBTQ activities. On the contrary, Mr. Chair, the recent census shows a continuing increase in the population of Ghana. In the population of Ghana, notwithstanding the so-called activities of LGBTQ persons. It shows that the allegation that is a threat to society and procreation is just a scaremongering allegation. It is not founded on any empirical evidence. Again, we will note that adultery, and the impregnation of teenagers by heterosexual males constitutes a far graver threat to family as a unit. This is obviously undeniable. Indeed, the idea of, in the bill, that the family is a lifelong relationship or unit is clearly contradicted by the persistent and regular divorces that are lawful under the laws of Ghana. Okay. Now, the other premise is that the majority of Ghanaians support it based on their cultural values.
Mr. Akoto Ampaw,
yes,
you have a long way to go. I forgot to prompt you that you need to do your presentation within 20 minutes.
Good.
Right. So maybe we'll give you 5 minutes to wind up.
Yeah.
Right.
Yeah. So
wind up.
Mr. Chair, even though the sponsors of the bill have been adept enough not to raise religious beliefs and convictions as a premise for the bill, it is obvious that this bill is in fact driven by religious beliefs and convictions. It is more than obvious to anybody saying it. And our point here is that whilst our religious institutions are respected and individual Ghanaians have the right to belong to any religion of their choice as guaranteed by the Constitution, the Constitution prohibits the imposition of any particular religious belief or tenet on the society as a whole. Because Ghana is neither a Christian theocracy nor an Islamic republic or a traditional kingdom or chiefdom.